Professor Aerospace Law from Leiden University. And then we have Professor Makarim Wibisono, PhD. And then we have Professor Atip Latiful Hayat. And then we have Professor Hikmahanto Juwana. And our great moderator is Mr. Alif Nur Fakhri Muhammad, Master of Law. And ladies and gentlemen, I will welcome. For the background, the ongoing conflict between Russia and Ukraine has sparked concern in the other region that other potential conflict may arise. One of these regions is the Southeast Asia and the South China Sea. The military operation conducted by the People's Republic of China within the region since early 2000s proved returning to the state's activities within the region. One of these activities is in international civil aviation. Airspace above the South China Sea is considered to be the high traffic airspace, carrying flights from Southeast Asia to East Asia. Even with the high volume of traffic, China's decision to impose an air defense identification zone, or ADIZ, above South China Sea may affect the safety of international civil aviation. Specifically, should civil aircraft refuse to identify itself on international airspace. For this reason, its discussion must be held in order to identify the jus in bello, or the law of war in international territories, with a specific interest on how international air law stipulates the jus in bello, both for belligerent parties and neutral parties in a region around international airspace. Past research was mainly focused on the treatment of civil aircraft by military force of states, resulting in a drafting enactment of the Article 3 bis of 1944 Chicago Convention. However, a discussion for the further discover other aspects of jus in bello in international air law is important to ensure the safety and security of international civil aviation. And next, I will give my control to the moderator, Mr. Alif Nur Fakhri, Master of Law. Please, Mr.
Thank you, Mas Rahmat, for the opportunity. First, I would like to thank you all for your attendance to our webinar. This is the first webinar arranged under the cooperation between the Center for International Studies, Universitas Indonesia, and the Center for Air Power Studies, Indonesian Center for Air Power Studies under PSAPI. On behalf of the chairman of the Center for International Studies, who is currently unable to attend this webinar, he expressed that he hoped that we will get something to bring out to each of our expertise, and also to contribute better to the field of on the studies of air law. And I would also would like to personally thank PSAPI for the opportunity, for the cooperation, and also for arranging the webinar, particularly on inviting all of the speakers and making sure that all of the speakers are present in this webinar. Now, after the background that has been given by Rahmat, I would like to first give the floor to PSAPI for 20 minutes to give a brief introduction to the problems that we will be discussing this afternoon, or in Pablo's time in the morning. To the PSAPI, the floor is yours.
Sorry, may I ask, before you do so, I just have one question, because otherwise I have to have to print the slides. Do you have, will the slides which I sent you, Alif, be visible on the screen, or will you not do that? Will you not present them?
I will, thank you, Prof. Pablo. I will be sharing your slides from through my screen.
Okay, perfect. Thank you. Sorry for interrupting. Excuse me.
No problem. PSAPI, time is yours.
Thank you very much. Dear ladies and gentlemen, first of all, I would like to welcome you to this very prestigious international webinar. Good morning and good evening for all of you. International webinar organized in collaboration between the Center for International Law Studies, University of Indonesia, and the Indonesia Center for Air Power Studies. I would like to thank all the committees who have worked hard for the implementation of this international webinar. The webinar will cover hot and up-to-date topics entitled The Role of International Air Law in Russia-Ukraine Conflict and Lessons that May be Taken for South China Sea Situation and South Asia region. We are grateful that this discussion will featuring the main speaker, Professor Pablo Mendes de Leon, Emeritus Professor of Air and Space Law at Leiden University. Very competent person in his field. My best friend and my teacher in the field of air and space law. As a layman, I learned a lot from him, especially from his book, which I personally received a few years ago in Leiden. The title of the book is Introduction to Air Law. Good morning, Professor. How are you?
I'm great, and I'm very happy with those very warm and generous words of welcome, Captain. And good afternoon, of course, to all of you. Two remarks to begin with. Firstly, I've left Leiden University, but I'm still a professor of air and space law at a number of universities, both in Europe and in other parts of the world, like China, India, South America. So I use the title now, Professor of Air and Space Law, The Hague. That is what you will see on the screen in half an hour or 20 minutes from now. The second thing I want to share with you, and I hope to be able to present it at a beautiful occasion physically in Indonesia, a country which I love enormously and where I have many friends, not only on Java, but also on Bali, who always invite me to come and visit them. And now that we can fly again, the 11th edition of Introduction to Air Law has been sent last week, the digital version, to Kluwer Law International, the publisher, and it will be ready for delivery, for presentation as from end of August, early September. And it is called Introduction to Air Law, but it is getting thicker and thicker. It has now nearly 450 to 500 pages, so it's a bit beyond introduction, but aviation, as we are exploring today, this afternoon with you, my friends, is becoming more and more complicated and multifaceted, which is a reason why introduction is actually not the right title anymore in terms of number of pages, but I hope to find an occasion to present to some of you the 11th edition at some point in time in your marvelous country. Thank you, Captain.
Okay, fantastic. Thanks a lot, Professor. We are also very lucky with the availability of experts who also discuss the topic of discussion in this webinar. Having been present with us, Professor, and also my teacher personally, Professor Makarim Wibisono, senior diplomat who is full and a lot of experience. Good afternoon, Pak Makarim. Next, Professor Atip Latiful Hayat is also my teacher, as well as professor at UNPAD or Pajajaran University. Good afternoon, Pak Atip.
Thank you.
And Professor Hikmahanto Juwana, also my teacher and professor at the University of Indonesia, Faculty of Law, who is currently serving an Unjani Chancellor, Rector University of General Ahmad Yani. Good afternoon, Mr. Hikmahanto.
Very good afternoon, Pak Cepi.
Thank you. Ladies and gentlemen, as an introduction and starter in this webinar, allow me to give a short presentation to enter the discussion according to the topic of the webinar. My presentation will be divided into several main parts, starting by looking at the conflict between Russia and Ukraine. Next, I will mention a short historical background, which will be followed later by discussing the law of the jungle. An interesting discussion because according to the late Professor Priyatna Abdul Rashid, the only tool to overcome arbitrariness so that the law of the jungle doesn't apply is a legal instrument. I will end the presentation by inviting all of us to anticipate some of the challenges that might arise in the development of future conflict in the South China Sea and Indo-Pacific region. Challenges related to the management of air power in dealing with conflict between nations in relation to the role of international law? Well, I start by looking first at what's going on in Russia and Ukraine conflict. Ukrainian President Volodymyr Zelensky has appealed to the United States to play its role as the world leader by designating Ukraine as a no-fly zone. This hope was dashed after receiving an answer from the President of the United States, Joe Biden, who stated that the most possible and reasonable thing for the United States to do was to only try to provide additional weapons assistance. America's answer clearly indicates that America doesn't want to be directly involved in the Russia-Ukraine conflict. America will not comply with Zelensky's request to establish a no-fly zone on Ukrainian territory, a decision that the United States must have made after listening to Putin's explanation regarding Russia's attack on Ukraine. Putin was very clear, as quoted by ABC News, that anyone who tries to hinder us, let alone create a threat to our country and its people, should know that Russia's response will be immediate and lead to consequences you have never faced before in history. This is a statement that smacks of a serious threat to anyone who interferes in the affairs of Russia-Ukraine. This threat will, of course, be related to the use of nuclear weapons. America will not take the risk because by doing so, the United States would be going head-to-head with Russian air power. Just an illustration of nuclear weapons, in this case, ICBM, Intercontinental Ballistic Missile with nuclear warhead. ICBM with nuclear warhead that can pass as fast as lightning between continents. In a note in the famous book entitled Fear, Trump in the White House by Bob Woodward, a document was obtained about the ICBM capabilities of the North Korean armed forces. North Korea already has an ICBM with a nuclear warhead capable of reaching Los Angeles in just 38 minutes since it was launched from a base in North Korea. With such an analogy, it can already be estimated how capable Russia's ICBMs are today. That is why the United States will not comply with Ukraine's request for a no-fly zone. Although, of course, the reason that arises is that Ukraine is not or has not become a member of NATO. That is also why Russia will most likely not allow Ukraine to become a member of NATO. Modern weapons technology has indeed developed very rapidly. Developed countries now do not feel it is enough just to have the Army, Navy, and Air Force. They have built a Space Force or aerospace forces. Modern weapon systems, and especially their command and control system, have used satellites that orbit in space. The determination of the no-fly zone is no exception. It will use a satellite-based command and control system. All of this only leads to the use of weapons that are mass destruction and accelerating the world towards doomsday. Hopefully, the Russia-Ukraine conflict can be quickly resolved at the negotiating table for and in the name of humanity. At this point, it is clear that international regulations are needed that can play a role in regulating the use of weapons of mass destruction so that conflict such as the Russia-Ukraine can be more easily resolved. Historical overview. As we all know that the Second World War has been successfully stopped by the United States by dropping atomic bomb on Hiroshima and Nagasaki, swallowing hundreds of thousands of dead, mostly civilian, has caused Japan to surrender. World War II was over after the use of the all-powerful atomic bomb. It cannot be denied that the bombing carried out by the United States was closely related to one of the triggers, namely the attack of the Royal Japanese Navy Air Fleet on Pearl Harbor in December 7, 1941. In the book, The Future of War by George and Meredith Friedman, the tragedy of Pearl Harbor is referred to as the origin of American military failure. More than 2,400 Americans were killed and 1,178 others were injured. After the end of the World War II, which used the atomic bomb as a weapon of mass destruction, internationally binding agreements were established to limit the use of nuclear weapon. That's why after 1945, even though there were so many conflicts in the world, the use of nuclear weapon could be avoided. Several conflicts that occurred and caused wars after the Second World War were recorded, including the Korean War, Vietnam War, and other wars that occurred in Iran, Iraq, Syria, Afghanistan, and several other locations. Fortunately, once again, fortunately, so far, the use of nuclear weapons appears to be avoidable by those involved in armed conflict. For the time being, the use of weapon of mass destruction appears to be or is still under control. The question is how long international regulation, treaties, and or laws can be respected. In this case, in terms of the use of weapon of mass destruction in armed conflict. Law of the jungle, who is the strongest wins. Unbalanced war history also record armed conflict that occurred in an unbalanced pattern, asymmetric. Restriction on the use of nuclear weapons are clearly unable to prevent armed conflict in various places in the world. Restriction on the use of nuclear weapons have even shifted the balance of power to countries that already have them. Restriction on the use of nuclear weapons have made the wars that occurred after World War II become very unbalanced. Some countries that already have nuclear weapons even tend to be arbitrary under the shadow of their weapons of mass destruction. From the various conflicts that occurs in the era of the end of the World War, it shows how dominant the countries possessing nuclear weapons are. Iraq, Syria, Palestine, and Afghanistan are just a few examples of how unbalanced their military power is and makes them powerless. Once again, because the shadow of nuclear weapons owned by certain countries has made them dominant. At this point, ideas arise about how to rearrange international rules that can enforce justice between all nations. Air power usage immediately after the end of the Second World War, actually all nations longed for a peaceful and prosperous world without another war that claimed many lives. The United Nations was formed, and various international organizations agreed to settle the demands of the war victims and lead them to the welfare of mankind in a peaceful world. International treaties were agreed with the aim that there would be no more conflict between nations which would resolve by means of violence. Agreement limiting the use of weapons of mass destruction were drafted so that the reoccurrence of world wars could be avoided. In fact, all of them are still unable to avoid conflict that are resolved by means of armed violence. The Korean War, Vietnam War, Middle East conflict, Palestine, and Afghanistan are examples of some of the wars that still occurs. Meanwhile, the military industry was even experiencing
Pak Cepi, I think you're disconnected.
referring to since the use of the atomic bombs in Hiroshima and Nagasaki, which succeeded in stopping the World War, it can be seen that the wars that follow relied heavily on air power. Weapon technology that is developing is dominated by Air Force weaponry, which turn out to be very powerful and efficient in an effort to win the war. That is why all countries have built their national defense forces with a total system. It was all as a result of war that had developed into a total war. It makes sense that the defense system that is built must also be under the total system as well. Air power has emerged as a very reliable force because it can be used as a suggestion for the use of weapons of mass destruction. This is the big challenge faced in the framework of the joint effort of all nations toward world peace. International air law to prevent war. The main problem today is how to resolve conflict in a peaceful manner without violence, because the resolution of conflict by violence of war always uses air and space means. international air law becomes very important. Rules, regulation, international convention regarding the use of air and space facilities play an important role in the management of world peace. In fact, all the time since the end of the Second World War, although there have been quite a number of rules and international law regarding restriction on the use of weapons, especially weapons of mass destruction, wars have continued. This is a big challenge for all of us, a war to be avoided. A war that always takes the life of those who are innocent and damage a number of other valuable materials. How to put international air law in the right position so that it can be respected or obeyed by every country. International air law should have a central role in the effort for world peace and the welfare of mankind. Even though war after war continues, we must be grateful that until now, hopefully in the future, there will be no war on the global scale. It is not clear whether countries that have weapons of mass destruction do not use them because they comply with the rules and regulations of international treaties or humanitarian norms that can still be upheld by world leaders who have power in their hand. Once again, the question is to what extent the role of international law is able to control conflict so that they do not lead into major wars. In Europe today, the war between Russia and Ukraine is not yet over. Meanwhile, the issue of the South China Sea with its various complexities await, as well as the issue of potential conflict that continue to occur. Dispute in Hong Kong and Taiwan have become other major challenges in the Indo-Pacific region. How to manage national air power, regional air power facing potential conflict in South China Sea or in Indo-Pacific region. Various issues have emerged recently in the South China Sea region. Several countries are involved in it, which are closely related to the well-known jargon, namely China with the One Belt, One Road policy, and China's territorial claims problem known as the 9-Dash Line. Among several issues that appear on the surface, there are maybe enough to invite attention in the management of air power in Indonesia, and especially in the Southeast Asia region. Regarding the determination of ADIS, Air Defense Identification Zone by China, and about a new creation trilateral security partnership called AUKUS, Australia, United Kingdom, and United States of America, especially in the ASEAN region, more importantly, in the perspective of managing airspace between Indonesia and Australia, there are at least two things that stood out that deserve to be highlighted or discussed. First, with the formation of AUKUS on the defense side of the country, there may be suspicions of the relationship between over-the-horizon radar belong to Australia and the operation of upcoming a nuclear-powered submarine of Australia. So far, Australia has always stated that the threat to Australia is the threat that comes through the north. The second is regarding the issue of airways over ALKI, Alur Laut Kepulauan Indonesia, term that used for innocent passage or sea lane passage that allows for a vessel to pass through the archipelagic and territorial waters of Indonesia. As is known as follow-up to the 1982 United Nations Convention Law of the Sea, which among other things mentioned the recognition of Indonesia as an archipelagic country, further problems have arisen. With the obligation of the archipelagic state to provide peaceful passage or ALKI, then comes the right to also use the airspace above the ALKI. It is at this point that the very principal difference between the international air law regime and the international law of the sea emerges. The law of the air doesn't recognize the peaceful passage or applicable in the law of the sea. Differences in principle that demand to be resolved immediately before developing later as one of the causes of conflict. For the note, in the international air law, All the countries have the same reference, 1944 Chicago Convention, that state that national air sovereignty is complete and exclusive. From all the description above, it is clear that we all need legal references that can be obeyed and respected internationally by all countries. This is where the role of international air law must be placed in its right position in the framework of managing natural air power and also regional air power in all regions in the world. Position of the role of international air law in relation to world peace and human welfare is crucial. Those are all the big challenges that we are facing now together to be discussed in order to reach a mutual agreement, an agreement that can be expected to lead us all to a safe, peace, and prosperous world. Thank you.
Thank you very much, Pak Cepi, for the introduction to the issues. Now, personally have highlighted lots of issues closely related to international air law, but also to international law in general, such as the Ukrainian proposal to impose a no-fly zone on Ukrainian airspace to the United States, and then also the importance in rearranging international law rules to ensure peace and security in all regions, specifically within the case of Indonesia in the South China Sea region, and also the role of international air law to settle international disputes. Then we will see further on how does international air law having its role to or its influence in during the dispute between Russia and Ukraine. And finally, there is the importance of application of other international law regimes to develop further and to ameliorate the study of international air law. Now, in relation to those four main issues that I've been highlighted, I would like to invite Professor Pablo Mendes de Leon, Professor of International Air and Space Law from The Hague, and also my former thesis supervisor. It is very much my honor to invite Professor Pablo to deliver his take on the issue at hand. Professor Pablo, the time is yours.
My dear Alif, I miss you in Holland, and I think we should catch up one day again in whatever part of the world.
Of course.
Because I'm happy to see you again, Alif, and we always had a very nice relationship, so I hope we can build on that in the future. I am delighted, as I said, to join this important conference webinar via digital platform. Maybe we can see the presentation on the screen, and then we will run through it slide by slide. And Alif, are you going to help me to to run through it?
Okay.
So there you have the correct title, which I now use after my Leiden period, so to say. And again, there are two central themes in this webinar, which have been identified also by Captain Chappie. One is the Ukraine-Russia conflict, war. The other one is the Air Defense Identification Zone established by China in the Chinese Sea. And I will try to address both of them in this brief intervention, which you graciously allow me to make this afternoon. Can we go to proceed to slide number 1, dear Alif? Yeah, this is the title, and the use of airspace in international relations. Yeah, exactly. Thank you so much. You will see already my conclusion, which is a 4th bullet point. But before getting there, I believe that this conference is providing a panoramic overview of challenges, topical challenges affecting international air transport with an obvious, and I believe that that is the common denominator, both from Captain PSAPI's presentation and mine about aviation security, because in the Chinese Sea there is no, at least not yet, let's hope it for that matter, not yet question of war. The two, let's say, incidents, i.e. the war in Ukraine and the establishment of the defense identification zone by China in its proclaimed Chinese Sea, have in common that they affect aviation security. They do not have in common that they pertain to how to solve war by treaties or by international relations. So I will discuss those points, status of affairs of aviation in the region around Indonesia, with, of course, special reference to the air defense identification zones. Of course, Captain PSAPI also referred to the status of the archipelagic seas, the internal sea of Indonesia as recognized by the United Nations Conference on the Law of the Sea. I will also say something about COVID-19, which may be a bit far-fetched for you, but you will see why I do that in a second. And then comes my conclusion. What are we witnessing now in this 21st century? The use of airspace as a strategic weapon. Khalif, may I invite you to proceed to the next slide? And we didn't really guess that, but in the 21st centuries, we have seen a number of events which were more like war, a term to which I will come later on, than we might have anticipated, because after the conclusion of the Chicago Convention, the term war was not that frequently employed as it is now. Why do I say that? After the Chicago Convention, which was of course built on the ashes of the Second World War, we had of course the Vietnam War in the 1970s, but apart from that local war, we had not much to do with warfare in the second half of the 20th century. But before getting to everything which happens now to us in the 21st century, I would like to recall the principal objectives of the Chicago Convention, which are, as we all know, the promotion of safety and security, which I mentioned before, on global rulemaking, and the protection of national airspace by closing it for security and economic reasons, fear of competition, which closure can only be lifted via international agreement between states. And those agreements have been concluded by all the states in the world. 193 states are a party to the Chicago Convention, including, of course, Indonesia, and they open up their airspace via bilateral agreements to airlines of other countries. And if you don't have that agreement, a foreign airline, and certainly not state aircraft, a matter which we are not going to discuss in detail in this intervention, will not be allowed to fly in your airspace. So with that, I would like to take you to the next slide with the kind assistance from Alif. Okay, closure of airspace. That was an exceptional measure, as I said a minute ago, in the 20th century, after, of course, the whole Second World War era. We had closure of airspace in Vietnam for military reasons, but also between India and Pakistan in the 1970s. By the way, between the two countries, we had the same closure of airspace for military reasons in 2019 or something. After 9/11, that was the beginning of the 21st century, as some people said, because it shed a light, it projected a bit what we are experiencing now again, closure of airspace for military reasons, for strategic reasons, also for safety reasons. So after 9/11, the US and Canada closed the airspace for, let's say, to maintain or to restore a peaceful use of airspace in those countries, in those two states, in those airspaces after the dramatic 9/11 attacks. Then on 14 April 2010, the volcanic eruptions in Iceland also led to closure of airspace on the North Atlantic region, Great Britain, Ireland, Denmark, the Netherlands, France, Germany, all those countries closed their airspace because of, in order to avoid spreading or the injection of ashes into the engines of the aircraft. Now we may want to go to the next slide. Yes. Now we come to something which was really quite unique in the history of airspace. 5 Arab states closed airspace for Qatar Airways, and Qatar Airways was not allowed to fly through the airspaces of those countries, which was quite a problem for Qatar Airways, because it has many flights from Doha, the capital of Qatar, to, let's say, Nairobi, to Johannesburg, to all kind of points, to Egypt, to points in Africa. So it had to make a detour via Iranian airspace and then avoid the airspaces of those countries, leading to extra cost, a lot of extra expenses for the airline, kerosene, and also personnel, because they had to work longer and things like that. So it's huge, hundreds of millions of dollars were lost by Qatar Airways, because they had to avoid that the airspaces of those 5 Arab states. Now, in the meantime, in January 2022, so more than a year ago, the Arab state decided to unblock their airspaces. But here you see that airspace was used as a strategic weapon in the somewhat inimical, somewhat hostile relations between the 6 states in question. And those are related to animosity because of jealousy, because Qatar has all those energy resources. There are also sheikh things, families which don't get along well. A very complex area, those Arab region, but anyway, it seems to go relatively okay at the moment. Then you will ask yourself, why do I mention COVID-19 pandemic? Because, well, many states closed their airspace and their airports for civil aircraft, but also for military aircraft. In some cases, civil aircraft or state aircraft, we are not going to fine-tune that definition now, were allowed to bring medical supplies, food supplies to countries who needed those supplies. Whether that was state or civil aircraft is at the moment a bit irrelevant. Now, at the moment, we are seeing that Western countries have closed their airspace for Russian airlines, and that is, and Russian airlines and Russian airspace is closed for the Western states who closed their airspace for Russian airlines. So if you want to fly from, let's say, Amsterdam to Tokyo, which you normally would do via Siberia, Siberian airspace, you now have to make a detour via Syria, which is possible again, by the way, Afghanistan, China, and so forth, which is also a detour. And the same as for Russian airlines are not allowed to fly to the West anymore, to these, which raises a lot of air law problems, by the way, which I will not discuss this morning, but it is extremely complicated. Bilateral air service agreements, slot allocation, traffic rights, all those questions come in. And when the peace will be restored, then we'll see how that will be resolved, whether we will have yet another Versailles Treaty or Nuremberg trials like after the Second World War. We are not yet there, but those points are already on the agenda. By the way, dear Captain PSAPI, you highlighted warfare in extremely interesting fashion with nuclear bombs and with no-fly zones. But above Ukraine, there is, as you of course know, Captain PSAPI, there is no-fly zones. The US and the Western state didn't want to impose that for political reasons. That's number one. The warfare at the moment is very classical. Tanks and soldiers on the ground. It looks a bit like the Second World War. There is no cyber attacks. There is thankfully not yet a nuclear weapon attack. And at the moment, it is extremely or relatively silent on what really happens. What we hear here is that the Ukraine army is pushing back Russian forces. We have no clue how it is going to end up at the moment. And the Russians apparently made a mistake in the beginning. They thought it could be what the Germans called a blitzkrieg, a very sudden war in which they would conquer Kiev, the capital, within 2 or 3 days. All of that has not happened. On the contrary, as we know now, we'll see how we will proceed from here. May we move to the next slide, please? Yes. What is the consequences of those closures? Cancellation of flights. Again, here we have also an air law dimension because you are very generously protected by European regulations when your flight is cancelled pursuant to the famous or infamous Regulation 261. That is not the subject of our discussions today, so I will leave that out. Closure of airports, of course, that was in the COVID period, not now. Traffic is picking up again. Schiphol Airport, our Amsterdam airport, is overcrowded. And then huge losses of income, already mentioned that, especially for the aviation stakeholders such as airlines and airports. Massive state support, especially for airlines, including in this country, also in this country, the Netherlands, but also France, Germany, less so the United Kingdom, Portugal, Spain, Italy, all of them helped their airlines, especially their airlines, by the way, to overcome the COVID crisis. And of course, significant disruptions of air traffic, both in Europe, but also in the Middle East, when Qatar Airways had to fly new routes from Qatar to destinations, especially in Africa. From here, I would like to move to the next slide, and then we are going to try to find a couple of legal aspects of this discussion. As I said, airspace is more used as a strategic weapon in warfare. That is what we witness a bit in the 21st century. But what is war? War there is no legal definition given in international treaties on the term war. Our Chicago Convention, also mentioned by Captain PSAPI, used the Chicago Convention, but the Chicago Convention has a provision which I never used in the 20th century, but which I used myriad times in the 21st century, which is Article 89. And it says, in case of war, the provisions, excuse me, the provisions of this Chicago Convention shall not affect the freedom of any of the contracting states affected, whether as belligerents or as neutrals. Now, what does that mean? That you can more or less do as you wish in times of war. You don't have to ask Ukraine. Russia can forbid Dutch or German airlines to fly through its airspace, irrespective of arrangements made in air services agreements or in the International Air Services Transit Agreement or in any other agreement. And the Netherlands and Germany and France and the UK and the US can do the same with Russian airlines, because all those flights are operated under the protection, so to say, of the Chicago Convention, i.e. Article 6. And normally air services agreements do not include a provision which says these traffic rights will not be, cannot be operated at times of war. But then you have this Article 89, which is a sort of a fallback position, which gives states the power to act as they wish at times of war. But what is war? Again, there is no definition of that. Not in the Chicago Convention and not in international treaties. And belligerence is not defined either, or neutrals is not defined either. Now, you may have read in your newspapers that Sweden and Finland are giving up their status as neutral states and becoming parties of the NATO, the North Atlantic Treaty Organization, which may move them from the status of neutrals to belligerents. But that is not so important, because any states can act as it wishes when there is war. We can discuss, of course, the position of Indonesia in this respect. Does it see itself at war with either Russia or with Ukraine, or does it articulate itself more as a neutral state? I would go for the latter, but I don't know, maybe we can discuss that. With that, I may take you to the next slide, that is with the help of, yes, no, sorry, the previous one. Sorry, the previous one. The last one was the one which was in my head, but I didn't know whether I put a line on it. President Trump and Macron said in 2019, we are at war with the coronavirus. In other words, the term war is used by heads of states, by treaties, without defining it. And that makes it a bit difficult to say we are at war or we are not at war. Why did heads of states, the presidents of France and the United States, say that? Because in times of war, as you can see in Article 89, the heads of states, the political leaders of the country, can act as they wish. They can say, okay, now we are the boss, we have to protect our populations from the danger of war, whether the enemy is the virus COVID-19 or the Russian Federation or China or whoever. So they can absorb all the power and they can act as the leaders of their country and try to get votes by guiding their states and their populations into the right direction, whatever that may be. Alif, can we move on? Well, there is something which looks like a sort of a definition, and you will find it in insurance policies, because insurance policies, that is more commercial aspects, which we're not going to discuss this morning, this afternoon, is liability. You know, liability, there are a lot of losses in times of war. I already mentioned Qatar Airways. Can Qatar Airways recover its losses because it is at war with the Arab states? And then the insurance policies say, no, we do not cover claims caused by war, invasion, acts of foreign enemies, hostilities, whether war be declared or not. That is another point. Sometimes international treaties say a war is only a war when it has been unilaterally been declared by the head of the state, i.e. Mr. Putin, or by Mr. Trump, or by Mr. whoever. In other words, war is a state of facts, not of law. Now, I put that picture on the left side because, I mean, this is a bit, looks like the First World War or even before, but I was saying before, in response to what, in response to the very interesting presentation of Captain Chappie, we are witnessing, or we are seeing at the moment, more or less a classical war, not as classical as what we see here, but it is tanks, it is soldiers, it is guns, and so on and so on. No cyber attacks, no no-fly zone, and no nuclear weapons as yet. Which brings us perhaps to the next slide, and that is about air defense identification zone. Now, this is not a matter of war, as I said previously, but this is a matter of not peace either, but this is a matter of aviation security and aviation safety. Why does a country want to establish an air defense identification zone? It is in a way very understandable, because when an aircraft has a state aircraft in this case, hostile intentions against another state, we can witness the 9/11. We can commemorate the 9/11 attacks in New York, and if such, let's say, a North Korean aircraft would suddenly approach Los Angeles or San Francisco, coastal cities, and the US could do nothing because it has no power outside the territorial sea, which is 10 miles outside of the airspace above it, outside of the coast, it is too short time to protect its own country, which is the same as for New York and Boston and all those big cities on the East Coast. And all the big cities in the US are located on the West end or the East Coast, except for perhaps Chicago and Detroit and a couple of others. But there are a couple of major cities on the coast. And so they want to make sure that when an aircraft with hostile intentions approaches its coast, it can intercept or at least ask the state aircraft, the foreign aircraft, what are you doing in my air defense identification zone? And if possible, if needed, take measures. Now, China is doing the same. We have seen the ADIS there on the left side, on the bottom, and it is establishing there or has established there since 2013 an air defense identification zone, but it is coupled with the claims of the Chinese government on certain islands and say they are part of my sovereign territory, including the airspace above it. So I'm entitled to do it. Now, as we have read, I don't know exactly where I read that, but it is not only a matter of inspecting aircraft. There are two things which are different here the Chinese zones, which are different from other air defense identification zones. One is you are not only inspecting or surveilling aircraft which is approaching your own territory, i.e. Shanghai or Beijing or other harbor cities or Hong Kong, but you're also, or the Chinese government also says we are going to inspect and surveil, we are also going to supervise aircraft flying from, let's say, Japan to Jakarta through that air defense identification zone, even if that aircraft doesn't have any intention to proceed to Shanghai, for instance. So aircraft in transit. The other one is use of force in case of non-compliance with operational air defense identification zones requirements from the Chinese. So there was quite a bit of opposition coming from the US, Japan, South Korea, Australia, Canada, and the UK against this measure, which was quite far going. Can we go on, dear Alif? What is an air defense identification zone? ICAO gave a definition which I reflected there on the slide: a special designated airspace of defined dimensions within which aircraft are required to comply with certain operational measures. And that is more or less it. Those operational measures differ from one air defense identification zone to another. Let's say radio and radar transponder, radio connections, radar transponder measures and things like that. And the creation of air defense identification zones goes back to the 1950s and the Cold War between the US and Russia, the then Soviet Union, and that was the reason why the US was afraid of Soviet aircraft approaching its airspace. And of course, the Republic of Korea and Japan, at the instigation of the US, by the way, did the same in those years. And after 9/11, again, the 21st century is a bit marked by concerns for aviation security, as also highlighted by Captain Chappie. And that is something we should deal with, that aviation security is really becoming a subject of the 21st century for the reasons I tried to explain in this brief presentation, which is also the reason why we have those air defense identification zones, which more or less coincide with the exclusive economic zone. Maybe we can move on, Alif. Now, is there a justification in international law for the establishment of air defense identification zone? No, neither in international law nor in international air law. I'm not convinced of the reference which some authors have done to Article 11, because Article 11 is specifically targets national airspace. That is where you can apply your air navigation rules, not outside. The more so because Article 12 says, and this is confirmed by Article 12 in conjunction with Articles 1 and 2 of the Chicago Convention, outside the territorial sea, we have the high seas. Of course, we leave aside now the discussion about the status of the airspace above the archipelagic sea, which was addressed by Captain Chappie, which is a specific matter for Indonesia. But for countries like states like the United States, like China, like Canada, and all those other countries which have established air defense identification zones, The high seas is the airspace above the high seas is the airspace where ICAO rules, Annex 2 rules, are being applied. With that, may I proceed to the next one, dear Alif? I'm nearly at my conclusions because I'm trespassing. I know that. So if you want to stop me, Ali, please do so. But I want to proceed to the next slide. Can we do that? Very helpful. Yes, and then comes the big question before I arrive at my conclusions. Can the establishment of an air defense identifications rule, the right to do that as a rule of customary law? I am inclined to say yes. I believe that can be regarded now as a rule of customary law because there is state practice, including Indonesia. Many states, or well, many 32 states have established such a zone, and there are no protests. Of course, the case of China is special because it goes beyond what has normally been applied in air defense identification zone, i.e. also aircraft in transit and far-going non-compliance measures. So I would be inclined to say, this is accepted as a rule of customary law, but you may think otherwise. I'm not going into the Lotus case. That is a bit maybe far-fetched for this discussion, where the Permanent Court of International Justice explained that only what has been allowed by international law is permitted in international relations. But the question is whether this rule is still, or this principle is still valid. And let's not go too deep into that at the moment, because that merits a workshop in itself. Which brings us to my concluding remarks. Thank you, Alif, for guiding us to that point. And you will find here things which are already said a bit. The use of airspace as a strategic weapon, in my view, and this specifically refers, of course, to India, Pakistan, to Qatar, Middle East, and so on, is not a good idea. Also now in the current Ukraine-Russia conflict. It does not preserve friendship and understanding as mandated by the Chicago Convention, the preamble, and it enhances friction, which it does at the moment, especially in the Ukraine-Russia conflict. And as I also said before, the second half of the 20th century was a bit marked by opening markets, liberalization of air transport. We all should communicate with each other as friends, as people around the world, via air transport, airlines, aircraft sales, and things like that. But that aspect must be a bit fine-tuned, to put it very nicely, at least in the first 2 decades of this century. And let's hope that that image will be lifted in the years to come, and that this is just a matter, all the events I mentioned, closure of airspace, conflicts, disruption of flights, and so on, is just a matter, has historical relevance when we look back at this period in a couple of years from now. Then I have a couple of very last remarks in the next slide. Thank you for taking us there, dear Alif. Or is it finished?
I believe that's all of your slides.
Oh, thank you so much, Ali. Thank you for your patience and understanding. You are a wonderful colleague in this matter, helpful assistant to take us through this presentation. Many thanks for your kind attention. And let's see what the next speakers are going to say about the topic of our conference today. Thank you.
Thank you, Professor Pablo, for the materials. It is very in-depth and also very, even though it's concise, but it's very in-depth to the material. You highlighted mainly on the use of airspace as a weapons of war through closure of airspace and many other things, which is already has maybe a loose basis under Article 89 of the Chicago Convention. But it's also interesting to highlight that in the two cases in relation to the closure of airspace at the ICJ, particularly the case of Pakistan versus India in 1970, and also the case of Bahrain and 5 other Arab states versus Qatar. Even though it is talking only about the jurisdiction of ICAO to decide on the matter, immediately after the ICJ decided that ICAO has the power to decide on the matter, all of these states that use airspace as weapons of war immediately lifted their ban for their adversaries aircraft. So I think this is a very interesting development of international law, but also in terms of international politics, because as I think Professor Marty Koskenemi has already written, that it is the two sides of the same coin. Now, because it is the two sides of the same coin, I would like to invite the 3 respondents, eminent professors of international relations, Professor Makarim Wibisono from Airlangga University, to give his response on the issue at hand. You will have 10 minutes to give your input and your take on the matter, followed by Professor Atip Latiful Hayat from Pajajaran University to give his input, and we will be also given input by Professor Hikmanto Juwana, who was used to be my bachelor thesis supervisor. So I'm having nostalgic feelings moderating discussion between Professor Hikmanto and also Professor Pablo, who were both my thesis supervisor during my studies. So without further ado, I would like to give the time to Professor Makarim. The time is yours.
Thank you so much. First of all, I would like to express my appreciation to Pusat Studi Air Power Indonesia, particularly the chairperson of Marshal PSAPI Hakim, and then also the Center for International Law Studies of University of Indonesia. I also would like to address to Professor Pablo Mendes de Leon, Professor Atip, Professor Hikmahanto, that they are all professor in international law. Not me, I'm just professor in international relations. I listened carefully with the presentation made by Professor Pablo, and before that I listened the introductory part from Marshal PSAPI Hakim, about the perspective of international air law with regard to international conflict. Even I'm not professor in international air law, but I spend time to understand better about the international air law. If we see the 1919 Paris Convention, it's recognized the full sovereignty of state over the space, over the airspace above their land and territorial sea. So the international law rule protecting sovereignty of state apply to the airspace as they do to the land below. As the International Court noted in the Nicaraguan case, the principle of respect for territorial sovereignty is also directly infringed by the unauthorized overflight of state territory by aircraft belong to or under the control of the government of another state. You can see it from the RCJ report 1986. Such unauthorized overflight would justify interception and a demand to land. So if we see conflict in Ukraine, we can see easily the cases about it. Yeah, sovereignty was understood to extend for an unlimited distance into the airspace, although this has been modified by the new law of outer space. The Chicago Convention on International Civil Aviation emphasized the complete and exclusive sovereignty of state over the airspace. And Article 6 reinforces this by providing that no scheduled international air service may be operated over or into the territory of a contracting state without the state's special authorization. So the state authorization of the host country is required by law. Yeah. The Chicago Conference reaffirmed the principle agreed in the 1919 Convention with regard to, for example, the sovereignty of the state over its airspace and the need for permission to operate scheduled international air service. Increasing violation of the world's airspace are a threat to a state sovereignty. An important aspect of maintaining sovereignty is the use of airspace security through the air defense system. One of the concepts of airspace security that has been implemented by states in the world is the air defense identification zone that explained very clearly by Professor Pablo de Medes. ADIS is early warning space through the airspace flight identification zone in support of a state sovereignty. The 1944 Chicago Convention and the United Nations Charter is the basis for the enactment of flight identification zone. So therefore, China issued about the ADIS for the South China Sea. Yeah. I would like to refer to Article 51 of the United Nations Charter, mentioned, I quote, "Nothing in the present charter shall impair the inherent right of individual or collective self-defense if an armed attack occurs against a member of the United Nations until the Security Council has taken measures necessary to maintain international peace and security." So the Russia mentioned frequently about their motivation based on defending the Article 51, because they see that the Ukrainian forces put pressure on the Luhansk and Donetsk populations there. Yeah, so therefore, the government of Russia on the 21st of February 2022 formally recognized the independence of Luhansk and Donetsk to provinces in eastern Ukraine with a majority of Russian speakers. Separatist troops loyal to Moscow had occupied the two provinces. So on Thursday, 24th of February 2022, Russia launched aerial, maritime, and land offensive military mission. So the reason of the military missions taken by Russia is actually for the defense of the Russian speaker in Luhansk and Donetsk that was under pressure by the Ukraine forces recently. So if you see the way that we see, I personally oversee that there are two competing relevancy between the legal argument and the political argument. Yeah, there are many discussed about, for example, legal argument, for example, on the South China Sea. Yeah, even Philippines bring the issues into the PCA in the Netherlands. Yeah, and then the PCA clearly mentions that what has been stated by China is actually irrelevant to the international law. Yeah, so therefore, the reaction of several countries are actually very firm with regard to the ADIS that has been pronounced by China government. Yeah, but in fact, you know, that we see that the issues cannot be resolved by the legal argument. Yeah, we see how is the problem in Palestine. Yeah, that started since before is the Nabang, when we saw the Nabang cases, that this is actually very long cases, but up to now, legal argument has been stated in this defense security of in United Security Council in the United Nations, but it is not respected by the belligerent country. Even there are resolution of the Security Council is disregarded by the belligerent party. So therefore, the case of Ukraine, as well as the issues that will be also discussed with regard to South China Sea, that actually will be also discussed, in several opportunity, is actually faces the challenge by the political argument. That now, for example, the issues of South China Sea is still there, and then the argument of legal arguments, even that are already decided by PCA, is have little impact to the issue in South China Sea. So I, as a international relations scientist, are interested to know, well, how far the international law, international air law, can give such kind like constructive impact to the real conflict in the area. Because up to now, we have seen that international organization does not work effectively. We see that United Nations has a Security Council that has authority to produce resolutions that have a legally binding, that every member of United Nations should follow the resolution of Security Council. But in fact, we see that in Syria, more than 600,000 people killed, but United Nations can do anything on the issue. We see also the case in Myanmar. There are about more than 600,000 removed from Myanmar, and then United Nations cannot do anything to address the problem. So this is actually a challenge for us to see how can we make that the international law, international air law, are well respected by a member of international community. Thank you so much.
Thank you for the very concise input, Prof. Makarim. You're really adhering to the time frame that I've given. And I also have highlighted that you're inclined to mention the role of international air law or airspace closure as part of national sovereignty, and also in support to those national sovereignty, there needs to be the imposition of ADIZ in general. Now, coming to the Russia-Ukraine conflict, as international politics expert, you are also highlighting the self-defense nature of the conflict, and also there are certain aspects of responsibility to protect from Russia to Russian ethnicity within parts of Ukraine. And coming to the South China Sea issues, there are legal arguments which have already been decided by the Permanent Court of Arbitration, have little to no impact in further in not making the problem any further. But we can also see on how international air law regime could contribute in trying to end the situation in the South China Sea. Maybe we could move flight routes, airways from above the South China Sea to through the airspace of the Philippines, who is party of International Air Services Transit Agreement, and is currently deciding on making archipelagic sea lanes and also airways above those archipelagic sea lanes to be open for international navigation. So moving on to the next responder, I'm going to ask Professor Atif Latiful Hayat from Pajajaran University to give his response to the issues and also his take on the matter. Atif, you have 10 minutes from now and the time is yours.
Thank you so much, Pak Alip Nur Fakhri. Good morning to Professor Pablo at The Hague, and good afternoon to Chief Air Marshal Cepi Hakim, Professor Makarim Wibisono, and Professor Hikmanto Yuwana. My response will be focused on airspace regulations and management in a spatial area, borrowing the words of Pak Cepi Hakim, is a critical border area. And this issue would be a response to how to resolve the maybe everlasting conflict in South China. Yeah. And I would like to have some listener from the Russia and Ukraine conflict here. Breach of airspace sovereignty, coercive aerial threats, and incidents involving civilians and military aircraft are all factors for conflict escalations. As already mentioned by Professor Pablo and Professor Makarim, China create overlap China's ideas, which has already been protested by Japan's, Taiwan's, and other countries. Washington and Moscow, for example, recognized this issue during the Cold War when they quietly negotiated in 1972 agreements on the prevention of incidents on and over the high seas. This accord circumscribes certain activities of naval vessels and their aviation, most notably the basing of vessels by naval aircraft. When the Cold War ended, efforts to circumscribe potentially dangerous activities waned. Instead, former adversaries reduced their offensive potentials and improved their airspace security through cooperative arrangements. This I would like to propose the model of cooperations in South China Sea. There are two possible models of cooperations: the Open Skies Treaty and airspace initiatives. The Open Skies Treaty is an unprecedented regime that facilitates cooperative area surveillance of military activities across the Euro-Atlantic region. The agreement currently includes 34 states and spans the territory from Vancouver to Vladivostok. Since its signing, Open Skies Treaty has worked to promote military transparency, facilitate the implementation of arms control accords, and to buttress deterrence. Today, the treaty is a keystone of the region's security architecture, and its continued relevance has been highlighted by its use during the Ukraine conflict. The Open Skies Treaty has allowed the aerial observations and imaging of the situation on the ground. It has also strengthened, for example, US and NATO efforts to reassure allies and partners. This treaty also has allowed Western countries to overfly Russian naval bases in the Black Sea area. And the second model is airspace initiatives. The airspace initiative can be in the form of exchange of air situational data between two or more countries, for example, NATO and NATO nations. It has become a relatively common practice in the Euro-Atlantic region. More than just a way to mitigate the risk of accidental or inadvertent escalation, the exchange of airspace data is a powerful transparency measure that has the potential to promote confidence, predictability, and security cooperations among neighbors and within a broader region. It offers additional detection time and the potential for improved coordination among neighbors in response to developments in their common airspace. Since their inceptions, US-led airspace initiative recognized that this type of cooperation carries the potential to build confidence, predictability, and security between neighbors and within the broader Euro-Atlantic region. At present, the infrastructure for the real-time exchange of information about airspace activity between NATO and non-NATO nations is available for use in the Euro-Atlantic. This infrastructure consists of 3 projects: the Regional Airspace Initiative, NATO's Air Situational Data Exchange, and the NATO-Russia Council Cooperative Airspace Initiative. Now move to the issue in South China. Although territorial disputes make up most of its international contention, China has also increasingly turned an eye toward the airspace of its coast and above disputed features. For some time, China has maintained that military operations within its exclusive economic zone are a threat to its national security, and repeatedly demanded that such flights, including surveillance flights, be stopped. China demands that the United States immediately cease this type of close reconnaissance activity, after again referring to the high seas some 50 nautical miles of Hainan Island as China's coastal waters. The demand to stop US surveillance flights within the undivided concept of China's coastal waters is not recognized under the international law, especially under the UNCLOS. Therefore, this is not supported by international law. Nevertheless, China's position is that it should be able to control foreign military activities that occur beyond the 12 nautical limit defined by UNCLOS. On November 23, 2013, the China's Ministry of National Defense announced the creation of an ADIS in the East China Sea. The establishment of this ADIS, the internationally recognized purpose of which is to provide threat identifications and early warning for aircraft intending to enter sovereign territory, would not have been provocative in and of itself if the ADIS had not been so blatantly established in disputed territory for geographical purposes that deviated from international agreements related to territorial airspace. Furthermore, the East China Sea ADIS was established unilaterally and in such a manner that it overlaps with the Japan and Taiwan ADIS. In the case of South Korea, China's ADIS also encompasses the disputed Socotra Rock, which prompted the Republic of Korea to extend its ADIS to cover the St. Peter 1 mile letter. In sum, the Chinese ADIS in the East China Sea appears to be a heavy-handed geopolitical move to support China's territorial claims against Japan and South Korea, rather than a genuine attempt to identify threats and achieve early warning of aircraft intending to enter its airspace. This, combined with ADIS regulations, normally reserved to control air traffic within territorial airspace that sometimes conflict with the claim and administered territories of other nations, strongly suggests that China is attempting to territorialize its airspace much farther beyond the 12 nautical limit defined in UNCLOS, amounting to an airspace grab. A summary of the evidence discussed above shows that first, Beijing seeks to control military activities beyond the 12 nautical miles of internationally recognized sovereignty from its territorial baseline. Second, China is increasingly capable of asserting its claim militarily and can bring substantial force to bear against regional states that violate this claim should it choose to do so. And third, China has established enforcement mechanisms such as an ADIS and military alert zone to support its extensive territorial claims. These enforcement mechanisms are designed to attempt to territorialize in contest with other nations the airspace over which China claims sovereignty. Now I'd like to contest with the United States argument. Current US policy is to rigorously uphold the principle of international law regarding airspace by flying wherever it is lawfully permitted without prior coordination with other countries.
I'm sorry, your time is up. Would you like to have 1 or 2 minutes to conclude your input on the matter?
Okay, can I have 5 minutes more?
Just 2 minutes, maybe.
Okay, the traditions of safeguarding access on the basis of international law and interest is therefore deeply embedded in the legislative US approach to international relations. Moreover, because the United States challenged the excessive claim not only of potential adversaries such as China and Iran, but also of allies and partners such as the Philippines, Taiwan, and India. No country can claim that it does so at the expense of any one particular state. Perhaps, I would like to jump through my conclusions because the time constraints. Perhaps the best models for a bilateral accord that eases Beijing concerns over persistent surveillance flights near its borders, while upholding the principle of international law, is the Open Sky Treaty between, as is already conducted by Russia and the United States before the Ukraine conflict. The Open Skies Treaty entered into force in 2002 and provides for surveillance flights over the sovereign territory of signatories, each of which must consent to a certain quota of surveillance flights per year, known as PSAPI quotas. The treaty allows the state to conduct the same number of surveillance flights it is required to accept, provide access to refueling bases so that participants can execute their flight operations, and establishes a coordination framework whereby notice of flights, aircraft regulations, and procedural issues are administered by the collective body of signatory nations. Thank you very much.
Thank you, Prof. Atif, for your input. I'm very much interested on your take on the cooperative arrangement to avoid conflict in the South China Sea, particularly taking at the Open Skies Treaty models of the European Union, and maybe also taking to look at the Eurocontrol agreement, maybe from the European states, to ensure that they are so intertwined in international legal treaty regimes that they can consider conflict is too costly, too disruptive to in this case air traffic within the South China Sea. Now, I would like to invite Professor Hikmahanto to give his input in the mixture of international law and also the international relations in the role of international air law in conflict resolution. Professor Hikmahanto, the time is yours.
Well, thank you very much, Alif, and thank you very much, Air Marshal Chapi Hakim, and also Professor Pablo. I have enjoyed your introduction and also the lecture from Professor Pablo. It is nice to hear from you again. I visited The Hague in Leiden when Alif was there. So it was nice.
I miss you guys.
Yes. Thank you very much. And I've also enjoyed the response from Professor Makarim and Professor Atif. Now, first of all, I must apologize that I may not take long because I have to be on television soon. But nevertheless, I would like to point out 3 important issues. One is I do agree with Professor Pablo that airspace has become a strategic weapon in warfare. So we understand that those who dominated the sky, they may have the advantage to win the war. And we've seen in the war in Ukraine, either the Ukraine or Russia, they not only uses aircraft, but also uses drone. And we understand that drone has played a very important role. They may minimize those who have the drone and then attack other military equipment from the other side. So I do agree that airspace as a strategic weapon in a warfare. My question then, as Professor Pablo mentioned, how are we going to say that there exists a war? Because if you look at the war in Ukraine, Russia said that they have not begin the war. What they have now, it's what they refer to as the special military operation. Even though other countries may say that, well, it is not a special military operation, this is an invasion, as if the war has begun. So the question is, from the international law perspective, from international humanitarian law, when does the use in bello in the activities of men in airspace began? Is it if there is an armed attack, only an armed attack, or there is a declaration of war? And whether it is between states, or it includes also states who thinks that its province would want to declare itself independence. Take example, the issue in Taiwan, because recently a delegation from the US came to Taiwan, and then they signed a treaty saying that if Taiwan is being attacked, then the United States will back them. The question is, of course, the US is have an eye on China. And what is the reason for China to attack Taiwan? Well, for China, if Taiwan declare independence, then for sure they will attack. But the question is this between a war between states, or this is a war between, well, it's not a war, it's an armed conflict between the central government against its certain province, but it is being backed up by a state. So it's going to be very difficult. This is where international law and international relations intertwine, and it is very difficult to ascertain, until the war or the armed conflict have ended, and there's going to be a court, of course, who will try those who become the culprit, usually those who lost the war. Well, that's the first issue. The second issue is on the air defense identification zone. Nowadays, a lot of countries, including Indonesia, may want to decide that we want to have the air identification zone. The question is, will the air identification zone a problem or a challenge to the safety of air navigation, the commercial air navigation? This is another issue. Of course, countries that have the air power, they may force down a certain aircraft, commercial aircraft. But if those who does not have the air power, but they want to establish the air identification zone, the question is, can they enforce that air identification zone? Or, of course, they will not force down the aircraft prior to entering their sovereignty. Yeah. it is a question, because if you look at the in the sea where you have the EEZ, for example, our Navy has been around the EEZ, but not because they become a military power, but because they want to enforce the law, especially the illegal fishing. And the next issue is, this is what I learned from the United States. We understand that within the Washington, D.C. area in Baltimore, they have set up an air identification zone. The question is, why it is so? Well, because probably the U.S. thinks that Washington D.C. is a capital city, and after the 9/11 incident, they need to protect securely the capital of the United States. So these are the three issues that I would like to raise, and I hope that maybe Professor Pablo have answer to this. And I would like to thank Professor Pablo for if he have answer to the issue that I've raised. Thank you very much. Thank you, Alif.
Thank you very much, Professor Hikmahanto, for the input. The three main issues, particularly on the strategic use of airspace as a weapon in warfare, in agreement with the point made by Professor Pablo, and also when does the use in below in airspace begin, particularly when it comes to the application of Article 39 of the Chicago Convention. And finally, in terms of air defense identification zone, we might want to look at the regimes of the law of the sea, particularly when naval forces and enforcing certain laws such as fisheries law, resources law on the EEZ. Maybe we could look on the practice of the fisheries law and law of the sea in general in order to create a certain standard on how states may impose their ADIZ without forcing aircraft down within their territory, or worse, outside of their territory. Maybe I would like to invite the participants in this seminar if they have their own input on the matter before I conclude. Or some question you would like to ask Professor Pablo or Professor Makarim, Professor Atip, or Professor Hikmahanto?
Otherwise, Alif, I can perhaps put forward a couple of thoughts, or I don't want to dominate or preempt other speakers. What about that?
Of course, we would like to hear your thoughts on the responses.
Yeah. The points which were made in this workshop, let me say that as a first remark, were extremely interesting. I'm not referring, of course, to my own points, but by the points made by my colleagues. And Alif, I also want to express my deep gratitude, but especially my pay tribute to the way in which you conduct this workshop and conference. Secondly, I want to emphasize that the subject which you have chosen for this conference and the points which are made by my sympathetic colleagues and friends in Indonesia inspire me to say there is much more to be said on these subjects, because they are all interrelated, they are linked, and they deserve a more in-depth exploration than the time we currently have for us. Now, a couple of arguments were not mentioned, also because of lack of time, in the context of the establishment of the air defense identification zones. The justification which has been put forward by states for establishing these zones, was self-defense. I must be able to defend myself against. For aircraft, which is laid down in Article 51 of the UN Charter. That's number one, and which is also laid down, by the way, in Article 3 bis of the Chicago Convention, which China could rely on no, China couldn't rely on that, which could be invoked when China would intercept civil aircraft. But anyway, that will be a rather complex discussion to enter into, so we leave it now outside of the scope of the current conference because it is too broad and too complex. I also heard one of my colleagues saying that this is a unilateral decision. That's absolutely true. That is inherent to the establishment of an air defense identification zone is a unilateral decision, like proclamation of war, to mention that. But it has legal effect, and sometimes air defense identification zone, and I said very prudently that is maybe the line of arguments I could follow, is that exclusive economic zones were also in the beginning, by the US, by the way, again, established as a unilateral measures, but it found its basis in a multilateral treaty at the end, i.e. the UN Conference on the Law of the Sea, UNCLOS 1981. And that happens sometimes to unilateral measures adopted by states, like ADIS, could perhaps also follow that path, that either an amendment of the Chicago Convention, which is a very complex task to undertake, or at least in perhaps an ICAO annex, giving it some international recognition, should we so wish. But again, I would be absolutely a strong promoter of, to begin with, a regional or an Indonesian conference where we could discuss this idea and explore these ideas and perhaps bring them to the attention of ICAO. And with that, I want to finish my intervention here, because I'm sure that other speakers who made extremely relevant remarks also want to say something. And we have 10 minutes left. You need a couple of minutes, Alif, for concluding. So this is where I want to stop. I didn't go into all the fascinating remarks made by the other speakers, but again, let's keep in mind that a workshop, a conference, webinar, whatever, will be a useful idea to further explore these issues. Thank you, Alif.
Thank you, Professor Pablo, for your input. This is very interesting, particularly on the matter of regional conferences on the matter, because looking back from the beginning of our seminar today, we can see that from the conflict between Russia and Ukraine, we can take your input that it is a proof that when airspace is used as a weapon of war, not just to shoot the weapons itself, but also to be used like some sort of a legal war between the belligerent state, and also not just belligerent state, but states supporting each of the belligerent parties. And also, I'm very much interested with what Prof. Makarim said, that is even when we look upon the South China Sea region, particularly the maritime dispute and also the airspace dispute within the region, any decisions made by international tribunals, such as the Permanent Court of Arbitration, is somewhat futile, having little to no impact on the matter. And it is more interesting, if I want going to continue to what Prof. Atif has mentioned, is to establish some sort of cooperation agreement to quote unquote force states to cooperate in managing the region. Looking at the example of not just the Eurocontrol agreement in Europe, but unfortunately, if we are looking back at the Eurocontrol agreement, in which Russia was not a part of the agreement, but had Russia may be part of the agreement as well as Ukraine. Perhaps the use of airspace as weapons of warfare could be averted. But since it could not be averted within South China Sea, perhaps this model could be used. We can also look at the regimes of maritime law and law of the sea, in which within the South China Sea, China has pushed to ASEAN countries, the Southeast Asian countries, to establish some sort of a code of conduct agreement in terms of maritime traffic within the area. Perhaps this agreement is could be applicable in within the ideas coined by Professor Atik. And also we have to remind ourselves that from based on the input from Professor Hikmanto, that in terms of enforcing this ADIZ, we have to also look at the other regimes, such as the regimes of the exclusive economic zones and the impositions of certain subject matter of law, such as fisheries law, resources law on the area, in order to establish a less forceful legal regimes within an ADIZ, especially those ADIZ which is situated outside of national sovereignty. And finally, I would like also to maybe add something on the ADIZ matter, that in terms of creating a regional cooperation within the South China Sea region, it is somewhat very plausible, because in order to impose this ADIZ, China should already have air navigational facilities, such as radar technologies and also other navigational equipment placed within the region that could be used for this cooperation. So we can see that there are lessons that may be taken from a conflict in a region to solve certain disputes within other region, and this is just from the side of international air law. Maybe that's the conclusion that I can take from the from our webinar this afternoon. And to conclude and to close this event, I would like to invite Pak Cepi to give his final remarks. Pak Cepi, the time is yours. I think Pak Cepi is still away. Maybe while waiting for, Pak Cepi is like, please, Pak Cepi, would like to add some final remarks on the conclusion? Pak Cepi are still muted.
Okay, sorry. Well, thank you, Salif. Thanks a lot for all of you, Professor Pablo, Professor Makarim, Professor Atip, and Professor Hikmahanto, and all the participants of this international webinar. It's very interesting, and I would like to put the two things that interesting to me myself is about ADIS and about the airspace use in above the sea lane passage. Maybe next time we can discuss it furthermore. And in this international webinar, we have a lot of open horizon about how the role of the international law in the especially in the relationship between the nation, and especially in the wartime. And again, thanks a lot for Alif and University of Indonesia for collaboration to organize this international webinar. Maybe in the time to come, we can make another topic to discuss. And again, for Professor Pablo, thanks a lot for your time. And also the other speakers, Pak Makarim, Pak Atip, dan Pak Hikmanto. Thanks a lot, and have a nice time, in good health, and see you next time. Thanks.
Maybe thank you, Pak Cepi, for your closing of the event. Now our event is already finished, and I really hope that next time we may have physical event with Pak Cepi and Prof. Makarim, Prof. Atip, Prof. Manto, and especially Professor Pablo from the Netherlands to be able to have this seminar in Indonesia, particularly in Jakarta and the University of Indonesia in Depok.
In Bali,
Okay.
Pablo in Bali.
Yeah.
That's the
Yeah,
post
I have friends
event
there, but also in Jakarta. Have a happy day, evening for all of you. And again, I leave my warmest congratulations for your professional guidance.
Thank
Very
you, Professor
professional. Okay.
Thanks a
I
lot.
have
Most
to move
welcome,
on.
Pablo.